Hello everyone, welcome to Apply Company Law Seminar 4, and today we are going into the topic inside the company, rules, members, and directors. Before going into the content of today, let me introduce my presentation group. First of all, it's me, Link, who is speaking right now. We also have Ethan Yan and Thu Chang Nguyen. Now, let's begin the topic today with the StandUp Ltd case study. 1. Factual issues. StandUp Ltd is a media company listed on the ASX with major shareholders in Australia, Asia, and North America. The CEO of StandUp Ltd is Pam, who has engaged the company in a prolonged period. However, the fact that corporate debt markets have been very constrained due to the turmoil in financial markets worldwide has led to the company's share price has halved in the past 9 months, and the cost of debt is going up. The acquisition are starting to hurt the profits. Some of the major institutional investors in StandUp Ltd are concerned about company's ability to continue servicing its debt obligations and have been petitioning StandUp Ltd board to regain the CEO's aggressive behavior with little effect. On 2 February 2020, a group of vocal members comprising a diverse group of 60 shareholders call themselves Shareholders United requisitioned the company to convene a members meeting and want the company to distribute an information booklet entitled Board Incompetence, a history of StandUp Ltd under Pam Power. 2. Legal issues. The board calls a SNAP members meeting to be held 14 days later on 16 February 2020. The notice of meeting does not contain the information booklet or the purpose of the meeting. The meeting is held at a conference center in Perth, which is unusual as normally the meetings are held in Sydney. The boards undertake this action to ensure that the attendance at the meeting is very low and voting is done mainly by the undirected process. At the meeting, the chairman refused to allow any of the members of the shareholder group to speak, and the resolution are defeated after the chairman votes the undirected process. The chairman then proposed, as a matter of special business, which was not detailed on the notice of meeting, an alteration of the company's constitution in the following manner. 1. All future meetings that are requisitioned by members will require board prior approval and 6 months notice. And 2. Dividends will be suspended for next 12 months to fund internal growth in the company. The constitutional alteration will pass by a special majority of shareholders presenting and entitled to vote at the meeting. Investors, including Shareholders United, are furious and want to challenge the outcome of the abnormal members meeting and its constitutional alteration. So, the question of Seminar 4 is, we are retained by the Shareholders United and have been asked to put together a brief outline of whether the board's conduct in calling and conducting the members' meeting, including this constitutional alteration, was valid. In other words, does the law permit the board to do these things?
Okay, so now I will be going through the relevant laws which apply here to this case study. So the first relevant law which you will see it talks about the conveying of a meeting, so section 249H. The amount of notice that is needed for a meeting to apply is 21 days notice must be given to all their members, all those attending the meeting. Note this does not apply to public companies or listed companies, so under section 249HA you need 28 days notice, and however, under a company constitution, it can specify a minimum longer period of notice, but you cannot specify a longer period of notice. So the days cannot be increased, but they may be decreased for the members. So as in the case study, 6 months is not allowed, but if you were to go to 20 days instead of 28, that is all fine. So next, under section 249 the contents of the meeting. So if you are to tell your members that you need a meeting, you need to give them 28 days. You also need to set out time, place and date for them to attend, and if they are unable to attend, you must facilitate something for them to be able to attend, whether it be through a proxy if they are unable to attend, or through use of technology, so zooming in or using Teams or something to give them the ability to be at the meeting even if they are not physically present. And in the meeting, if you are to do a special resolution, which means maybe changing the constitution, like in the case study, you must tell members beforehand and the intention of the purpose of the special resolution, and as well as just general information of what is going to go on within the meeting. And as said before, proxies are allowed. Also, next for 249Q, the meeting must be held for a proper purpose, and a good case to look at for this is NRMA versus Parker. So you cannot just hold a meeting for no reason. There needs to be a reason for the meeting. And then for Section 249N members' resolutions, the following members may give the company notice of resolution that they propose to a more general meeting, and members within 5% votes can be cast for the resolution, and at least 100 members are entitled to vote at a general meeting. And the notice must be given in writing and set out if there is a special resolution, as I mentioned in before, and it must be signed as well. So now moving on to the conduct of the meeting. So under section 249R, the time and place for meetings, as mentioned previously, must also be given at a reasonable time and a reasonable place. So maybe this is a recurring place or something like that. So a case to look at would be Smith versus Sadler for something similar or something applying to this. And so finally was constitutional alteration. So the under section 148, the effective constitutional and replaceable rules. A company's constitution, if they have any, and replaceable rules that apply to a company have effect as a contract between the members and each other members, and also between directors and the company and members. So under section 232 and 23, grounds for a court order. So that means if the company does change the constitution in a way that makes members unhappy, they can go to the court about it. So under C here, a resolution proposed members of the class of members of the company is contrary to the interests of the members, so the members don't agree, or it's in contrast to what they want, and oppressive to any of the members, or something, or discriminatory to any of the members in any capacity.
For law applications.
In application part, the first question is who called the meeting. In the section 249 and subsection 1, member with at least 5% of the votes may be cast on resolution. At least 100 members who are entitled to vote at the general meeting. Also in the section 249 and subsection 2, the meeting must be in writing, set out the wording of the proposed resolution, and be signed by the member proposing to move the resolution. So back to our case. In the meetings were requested by the group of 60 shareholders, which is not satisfied by the minimum of 100. And also there's no proof that the 60 shareholders hold at least 5% of the vote. And in terms of the notice, this case only showed the proposed resolution but not mentioned the notice be written or signed by the shareholders. So in terms of the conducting meeting, the question is, were the meeting held for a proper purpose? Under section 249Q, a meeting of the company member may be held for a proper purpose. The relevant case here is Parker case, where the meeting did not hold because of the improper purpose. Back to our case, the shareholder wanted the company to distribute the information booklet entitled Boarded Incompetence, a history of StandUp Ltd under Palm Power. So the next question is, were the amount of notice valid? Under Section 249H, at least 21 days of notice must be given to the member about meeting. However, under Section 249HA subsection 1, at least 28 days of notice must be applied for the meeting of the listed company. In this case, StandUp Ltd is a listed company, and however, the board called SNAP a member meeting to be held 14 days later, so the amount of the notice is invalid, which should have been given at least 28 days instead of 14 days. So now to answer the question, was the content of notice valid? We will use the Section 249 and Section 136. Under Section 249L subsection 1 and 2, the notice of the meeting of the company members must set out the place, time, and date for the meeting, and also state the general nature of the meeting business. Under Section 249L subsection 1c, the notice must also include the special resolution is to be proposed at the meeting. And in the Section 2136, it's allowed that a change of the constitution of the company must have special resolution, and this topic must be given to the member 21 days before the meeting. In our case, the notice of the meeting does not contain in the information booklet or the purpose of the meeting. However, it's mentioned about the place, time, and date for the meeting. The notice did not set out the intention for an alteration of the company constitution, and the director of StandUp Ltd also failed to notify the member about this. And StandUp Ltd is the public company, but must also file a amended constitution with ASIC, but they also failed to do that. So the next question is, was the meeting validly held? Under Section 249R, a meeting of the company's members must be held at a reasonable time and place. In this case, the meeting was held at the conference center in Perth, which is unusual because normally the meetings are held in Sydney. The relevant case here is Smith and Sadler case, that the meeting also was held in an unreasonable place. So the meeting was held in unreasonable and unusual place, which breached the Section 249R. So in terms of rights of process, under Section 249Y, subsection 1A, a proxy appointed to attend and vote for the member has the same right as the member to speak at the meeting. In this case, the chairman of StandUp Ltd refused to allow any member of the shareholder board to speak. Therefore, one of the rights of the process was rejected, and this did not satisfy the Section 249Y. So the last question raised in this case is, was the constitutional alteration valid? Under Section 249HA subsection 1, at least 28 days notice must be given of the member of the listed company, and in this case, the chairman proposed all the future meetings that are requested by the member will be required the board prior approval and the 6-month notice. This alteration was invalid because any meetings required by the member only need at least 28 days of notice.
5. Conclusion. After the application mentioned above, the advice that we would like to give shareholders united is that constitutional alteration made by the director can be considered invalid in StandUp Ltd case study because of the circumstances that the alteration were made in. So, the director of StandUp Ltd did not abide the law in the manner of calling the meeting under the section 249HA, 249R, and 249Y. The behavior and decisions made within the meeting as well as the alteration of StandUp Ltd constitution under section 249M. That is the end of the presentation today. Thank you for your listening, and if you have any question about the topic or anything unclear, please don't hesitate to raise questions. Thank you.